is, I did not check to see if it was okay with them. Since we're on YouTube, I would prefer just to use their initials and not to say their names. Is that okay?
I think so, unless it gets confusing.
Okay, okay. So we're here as a result of an order that Chancery Court handed down granting summary judgment in favor of Carlex for a discrimination claim that my client, Ms. Bertrand, filed under TCA 421-401. Ms. Bertrand is a chemical engineer with a master's degree in business administration. She had worked for Carlex since 2011, but it's really known as the Ford glass plant. So through the years, there's been various ownerships, and Carlex got the company in 2011. My client has been working for the plant since 1997. So throughout her career from 1997 to 2019, she never had any problems. All of her yearly evaluations were great. Her yearly evaluations with Carlex since 2011 were great. During the pandemic, April 8th of 2020, while they were working from home, she got a call from BM, who is the human resources person, stating that she was going to lose her job because of a reduction in force. I'm going to now call it a RIF, so when you hear me say RIF, I mean reduction in force. Okay, so she was saying, BM told my client that due to COVID, she was going to be terminated. There was a severance package that was offered to the employees. My client turned it down. She wanted more. 44 employees were terminated, 39 were corporate. My client was the only African-American manager terminated. All the other white managers were allowed to remain.
You mentioned, you framed it that way in your brief as well, and I want to ask you, are you suggesting there's a statistical argument here going to, no, okay.
Yeah, the sample was too small to even do a statistical, because we're only dealing with 44 people, 39 corporate.
So we're really, and it sounds like you're acknowledging no direct evidence here. This is a circumstantial evidence in this case.
Right, okay. Right, and that's what I said in my brief, that I believe that this is circumstantial. This is not a direct method case, but this is a McDonnell-Douglas case, purely McDonnell-Douglas. Now, I want to talk a little bit about the summary judgment requirement. We all know that the trial court's order has no bearing here. I bring that to mind because Carlex's brief couches the issue is, was the trial court correct? And I just want to emphasize that we understand that you all get a fresh look at this particular case. So the first thing I want to talk about is the prima facie case that my client is supposed to prove first under McDonnell-Douglas. Now, there are 4 factors for discrimination, and the first one is, was she in a protected class? Of course she was. She's a black female. The second one is, was she subjected to an adverse employment decision? Of course she was. She is she was terminated because of the RIF. The third one is, was she qualified for the job? My client is a mechanical engineer, MBA. Of course she's qualified. The issue that we have is number 4. I think that's where our material issue lies. When you're dealing with a RIF, the normal 4th prong, which is whether the person was outside of protected class or treated differently, is gone. So the 4th one for RIFs are, did the plaintiff must provide additional direct, circumstantial, or statistical evidence tending to indicate the employer singled out the plaintiff for discharge. That is what this case is about. My client never had any problems prior to this RIF. Didn't even know about the problems. The issue that we have here is when you have an employee that has no problems for the yearly evaluations, and then an employer who all of a sudden says that there is a problem, is that pretextual? In my brief, I talk about how we filed this complaint in April of 2021. That's when it was filed. We did discovery. In the answer to the complaint, the question was, Carlex said she was terminated for non-discriminatory legitimate reasons. So in discovery, I specifically say, please give me those reasons. In the answer, they give me the same answer, non-discriminatory, legitimate reasons. So we go to depositions of the Rule 30 corporate designee, which is RT, which is very important. I ask at the deposition, what were the issues that Ms. Bertrand had? Because I can't see it in any of the discovery. All the discovery that we had, it was a whole personnel file that had no problems.
And this was the late submitted 2020 review we're talking about.
When we had that deposition, it was not produced, so we didn't even know it existed. So during the deposition, I'm trying to figure out what the problem is. I have nothing to show that she has a problem. The answer to me is, well, a 2019 evaluation probably does not exist. So we're going forward with the deposition with no issues showing that Ms. Bertrand had any of these issues. At the Rule 30 deposition, they said she had 3 issues: lack of ability to negotiate with suppliers, developing positive working relationships with supplier issues, and understanding when it was necessary to actually go and see and visit the supplier to address issues and concerns. However, her evaluation said that she had a commitment to excellence and works in a climate of cooperation. So I have nothing to substantiate what he's saying. After the Rule 30 deposition, all of a sudden they find a evaluation, and that is the one that's the problem. So I had to redepose the Rule 30 to say, where did this thing come from? Now, we find that suspect because the issues that Ms. Bertrand apparently had was never discussed with her.
So let me ask you about the evaluation process at Carlex, and I want to make sure I understand, because I have not looked at this report yet in the record. I get the impression that customarily in a review, the employee would be involved in that process so that their comments or portion of it would show up. Did it in this late produced report?
No, what happened is my client, in the beginning, my client was a mid-level manager, so she had to do this for other people herself. So what you do is, you're the employee, you make your comments, you meet with your supervisor before the evaluation year is over. If there's any issues, you discuss it, and then you have the evaluation. My client did a Rule 72 declaration saying none of that stuff happened. The only thing that she did was fill her stuff out. There was never any meetings with her boss. There was never any discussions about her performance. Nothing was ever done. And she did not think that this 2019 evaluation even existed, and neither did Carlex.
Okay, so I think I understand. So what you're saying is that your client's recollection was at the end of 2019 or after 2019, she submitted a self-evaluation.
Right.
But that's it. Okay.
Right, no discussion with MR, no meetings, no nothing. And in fact, in MR's Rule 72 declaration, he stated he never discussed these issues with her or anybody.
Counsel, is there evidence in the record as to whether the 2019 process was different than other years at Carlex? And was it different than her experience in 2018, 2017, in terms of how that process worked with the evaluation?
Well, my client, because she had to do it for people, talked about how the process was supposed to be in 2019. So she discussed what they normally do, which is you meet with the employee, you have meetings throughout the year, and then you do the evaluation.
So
She says,
there is evidence in the record that that's the normal process.
right, that's what she testified to, because that's what she did it too.
Okay.
So she did a Rule 72 declaration, but she didn't have an opportunity to talk about that because when they deposed her, this evaluation didn't exist. So it popped up later. So I'm saying all that to say is that a jury needs to be able to decide whether that is a shifting of explanations. On top of that, we have this email by RT that says, please, have you talked to Yvonne? Please let it slip that MR was terminated. The optics look better. MR is a white man. RT is a white man. And Ms. Bertrand is a black female. That should at least, coupled with this magically appearing 2019 evaluation that appeared after the complaint was filed, this optics situation that was said on April the 22nd, which is 14 days after she was terminated. I think that a jury should say, okay, why are they saying this? Ms. Bertrand was the only black female that was terminated. I'm sorry, not the only black female, the only black female manager that was terminated.
So the other gentleman that was retained, L.
Yes.
AL? Is that
ALJ,
it? Thank
yeah.
you. Okay, AL. Didn't the record show that at one time, though, your client reported to AL?
I don't believe that AL and my client, years ago they did, but AL and my client were on the same level at the time of the RIF. They were not, they were colleagues. It was not.
They were both reporting to MR.
They was both reporting to MR at that time.
Okay.
And he said that there was no issues there with Ms. Bertrand, even though he's not a manager that makes the decision. But the issues that MR had with Ms. Bertrand was never communicated to anybody. It was never told to her, never told to anybody, and they rely on that, that his statement to say that he had an honest belief. But honest belief doesn't just require you to take their word for it. There must be something. There's no facts to suggest that she had any of these issues, and MR never told anybody she had these issues. So looking at the burden shifting part of McDonald, I believe that these three things, the magically appearing 2019 evaluation, the yearly, the personnel file that shows no problems, and then this optic email is enough for a jury to decide whether the decision to terminate Ms. Bertrand is pretextual. If she can't do that, then I don't know what else anybody can prove on RIFs.
Okay,
Thank
and I'm going to keep you there one more second. So those three things together are the circumstantial evidence that makes your prima facie case under the fourth prong.
Yes, Your Honor.
Okay, thank you.
Good morning, I'm Howard Jackson with the Knoxville Bar representing Carlex. Appreciate your time this morning. I would point out just initially that in the trial court's order, it dealt very thoroughly with all of the issues that were just raised. I want to talk about the prima facie case for a moment. It's acknowledged by everybody that we have to have some additional evidence beyond the fact that I'm in a protected class and I was competent and I was reduced in a RIF, because competent people get reduced in a RIF. Well, there's no statistical evidence, there's no comments, and this business about the RT email, it's acknowledged in the record, it's the testimony in the record that he was not a decision maker. He played zero role in deciding who was going to be let go in the RIF. And we cited the court to the case law that says, and that's a pretty vague remark to begin with, but it's by a non-decision maker after the fact of the decision having been made. So there's no probative evidence based on that comment. The 2019 performance evaluation, the plaintiff was allowed to depose RT a second time, specifically to ask about that. And the explanation is, at a point in time, the company went to a different HR management system. And he's, well, when the person I asked to send the file, they only looked in the old place and they didn't look in a new place. And that hit me while I was sitting here in my other deposition. And so I went and I found it, and there it is, and we produced it. But it's really, and the trial court said this as well in its order, even if you completely ignore the 2019 evaluation, what we have is Ms. MR's affidavit that states that he made personal observations when it came down to, I got to choose between these two people. And based on my personal observations of their performance, I considered AL to be superior in a few specific ways. Not that Ms. Bertrand was in any trouble, are about to be terminated, but that when you go to compare the two of them, I find, based on my observations, that he had greater skills in certain areas, and so that's who I'm going to retain. But I've skipped ahead a little bit because that really comes in only, I think, at the pretext stage. I would submit to the court that the trial court got it right, that there's no additional evidence of discrimination to make the prima facie case, and that the case fails here at that stage. You don't even have to get to pretext because there's no statistics, there's no comments, there's no thing that points to race or gender as having played a great role in this context that gets you over that Barnes Corporation case, or the Barnes case, that we've all agreed sets the right standard. So the case fails at that stage. If you get to the pretext stage, and the trial court discussed this in its very thorough order, now you've got to go, okay, is there evidence that there's no basis for the decision at all? Well, the basis is MR's personal observations that he looked at when he worked with these people. And again, it's not as though anybody says Ms. Bertrand was in difficulties such that she was in danger of job loss before this rift. She was not.
What about those issues were never communicated to her?
Well, I think that Mr. MR put in his affidavit that these were his observations. He put those on the 19 eval. And to go back to that for a second, to Your Honor's question on the eval, I wanted to mention while I'm here, that we got to remember here that we're in March of 2020. So, and it shows, the eval shows on the face of it that the input was put into it in February of 2020, which was not unusual for the previous year. That's relatively early in the year. But then what hits in March of 2020, we're scrambling. And now I get a call, I got to reduce somebody. So no, they didn't meet. They didn't meet. There's no question they didn't meet. But they didn't meet because kind of an obvious inference is the house is on fire. And we're going to have a rift, we're going to cut these positions. What are we going to do with all the COVID stuff? So yeah, they both put in their input, but no, they never met.
Counsel, are the previous performance evaluations in tension with the testimony as to the purported deficiencies of the employee?
Previous evaluations are positive. There's a little bit of commentary about interpersonal relations, but there's nothing that's a needs improvement until the later one. But there's some commentary in the previous ones. And there's also commentary that Ms. Bertrand in the preceding year had assumed a new role. She'd been given a different role, and this is discussed in the 19 eval. I don't think in his affidavit. I think the affidavit just focuses on what do I see when I compare these two people. So, Mr. Reiser's personal observations form a basis. There's no direct evidence. There's no indications of comparators who were treated worse in any way in terms of the RIF. And there's just nothing that sort of undercuts the veracity of his opinion. And as the trial court talked about, at some point you've got to have evidence that this was not an honestly held belief. Where's the specific fact that undercuts that once it's been presented that this is our legitimate ground for our decision-making basis? Where is the specific fact that dissolves that, or at least undercuts that? And I don't think that we have that here in this case.
Counsel, do you agree that the 2019 evaluation process was inconsistent with the company's normal policy in terms of how evaluations are supposed to be done?
Yes and no. In the sense that ordinarily you do meet and discuss, but that was interrupted here by the pandemic and a RIF. I mean, had there been no pandemic, there would have been a meeting in probably March or April.
Well, the timing doesn't quite work, it seems to me. It seems like we all shut down in late March of 2020. And, I mean, that just seems very late in the process to have not had the meeting by that point. I mean, I did read with interest the Chancellor's order on the motion to alter amend about the discovery of the report, and it strikes me, you know, she analyzed it as if, well, it makes sense that they would produce it if they had it because it supports their case. But, you know, taking a more cynical view, I could also see the argument made that, well, it was made up in order to support RT's testimony here, or MR's testimony about the job performance. So, I mean, cynically, that's one potential reading of it.
May I address that?
Sure, please.
On the face of the document, there are notations that the entries were made in February, which was before anybody knew that we were going to have a RIF. So that timing kind of doesn't work as a made up after the fact kind of reason, but they both made their entries in February before anybody knew, and then he didn't get around to meeting, and yeah, we can argue about that. But as far as it being made up, there's evidence on the face of the document as to when the entries were made, and so there's no actual factual evidence to support this sort of allegation of, well, it was all just made up. In fact, to the extent there's evidence in the record, it's to the contrary, based on the dates on the entries on the face of the document. So that's just an argument. There's just no fact to support it. And I want to address briefly as well this idea of, well, maybe there are shifting reasons. Well, and we cited the court cases on this subject in our brief. In order for there to be shifting reasons, they have to be inconsistent. In this case, we said in interrogatory responses, we had legitimate non-discriminatory reasons for the selection of the people in the RIF. At Mr. RT's deposition, he listed 4 reasons, and we've cited them or the court cited them in their final memorandum in order on page 17 of his testimony, that the corporate rep's testimony cited 4 reasons. And then in MR's affidavit, he's referred to and expounded upon a little bit those same 4 reasons, same reasons. So there's nothing inconsistent with saying we had legitimate reasons, now here they are again. The 2 witnesses were very consistent in the reasoning that they gave. So there aren't shifting reasons here. There's additional reasons after the interrogatory response. So that method of proving pretext, it doesn't work here on the facts.
Counsel, legitimate business reasons is an extraordinarily vague explanation for, and that essentially could be an umbrella over almost any explanation. Is that a problematic response in the context of the more specific information that developed here? And you have a concern raised in terms of, you know, this rationale seems to develop through the process, and maybe that wasn't the rationale at the time of the decision itself, or at least raises issues as to it. Why isn't that the right way to think about it?
Well, first of all, because legitimate reasons that are business related, yes, it's not as specific. When you remember, MR was gone from the company at this point too. But that's a legitimate response. And then when we were asked for more specific reasons, we gave the same ones every time, which are also on the February 2019 performance review. So there just aren't facts to support that something was made up later. The record doesn't support that. So in summary, it's my suggestion that the trial court got it right, that there's not the additional evidence that's required for the prima facie case. That was a specific conclusion in the order, as well as that there's not specific evidence that's required to create an issue or pretext. Those things, when you really analyze what's been submitted here, the email by a non-decision maker, a performance review that is simply consistent with what Mr. Reister said in his affidavit, which has a date stamp on it for the entry of the material, and the supposed inconsistent reasons, none of those stand up on analysis of the facts. If this court has no other questions, I'll be glad to sit down.
Don't see any. Thank you.
Thank you, sir.
Ms. Wade, you have 3 minutes for rebuttal.
Yeah, if I can respond about the decision to terminate Ms. Bertrand, there wasn't a requirement to terminate somebody. It was the requirement just to reduce cost. So they could have found another way to do it other than terminating Ms. Bertrand. So it wasn't like I had to pick somebody. That wasn't what that was. He just decided that Ms. Bertrand would be terminated. Also, the issue about the statement about the optics, that's the Wilson v. Rubin case, and I think that that does not, it's not for the proposition that a decision maker has to say that. Wilson v. Rubin was for the proposition that if you're not using the direct evidence method, you can use a circumstantial method under McDonald, and that's what we're using. RT was the RIF person. He was a manager. He was over BM, the HR person. He talked to MR and he talked to DM. He was a manager, and he said this in this email about the optics. So to disregard that, to say, no, it doesn't matter, I think that that's unfair. It's like if you have a stew has potatoes, carrots, meats, and everything. You can't take the potato and say you're not a stew because you're a potato. It's all in the stew together that makes the racial discrimination.
Counsel, when you say the RIF person, what do you mean by that?
He was the manager over the RIF. He was over
Okay,
the
so he
process.
was managing the whole process.
Right,
but
the
then-
Rule 30 corporate designee was over the whole entire process. So he had a role in this RIF. Now, the issue about honest belief, it's not just the word honest belief. It has to have some type of other facts to justify it. Nothing that Carlex has said is supported by anything. You're not going to find any facts in the record to justify what they say her problem was. There's nothing in there.
We've spent a lot of time on the reduction of force, and I want to make sure we don't overlook the severance component of this. So
yes.
could you spend whatever you have remaining of your
Yes,
time
yes.
there to?
So SE is a white male who had 14 years of service with Carlex over the Fort Glass Motor Plant. He had retired in 2006 and came back, but he had 14 years. The rule was that 26 is severance pay for anybody over 15 years. My client had over 15 years. SE did not. SE went to Carlex to ask for more money, and they gave it to him. 26 weeks. Ms. Bertrand asked for more money, and they said, we can't give you over 26 weeks because we're not giving anybody over 26 weeks. Our argument is, why did SE get favoritism, basically, to get over what he's required to get, and she couldn't get the same consideration? So he got 26 weeks. He only deserved 13. She got 26 weeks and got no consideration for anything else.
So why wasn't the stacking, though, of his time period with Carlex and its predecessor sufficient to get him more?
Because according to their policy, he retired, right? So there was a retirement phrase before Carlex took over.
Okay.
So he didn't get credit for the time when he stopped and then he got rehired, even though it was short. There was too much of a gap. There was too much of a gap in between that. So they gave him 14 years of service, so he got 26 when he really should have got 14. So her argument is, what's good for the goose? Why did he get extra consideration, and when I asked for it, I don't? Their argument is nobody got over 26 weeks, but he got over 26 weeks when he wasn't entitled to it. So that's where she says that there's discrimination there. SE did an affidavit for us, and he did say that he was not supposed to get 26 weeks. Lastly,
Yeah, sum up. Your time's up.
oh, okay, I thought it was, okay, thank you.
Time flies when you're having a good time.
Thank you both very much. Very good arguments. And we'll issue an opinion in due course. Would you please call the next case?
In Re Estate of William Rucker.